Now we go in depth on some legal decisions. DNA evidence leading the Florida Supreme Court to throw out the conviction of a death row inmate. A split court overturning the death sentence for that inmate after new DNA evidence raised questions about whether or not he actually committed the crime for which he was on death row. Joining us now to discuss the case, criminal defense attorney Janet Johnson. Janet, we thank you for Skyping in here on America's Forum.
Thanks for having me.
Janet, bottom line, did the court make the right decision in this case?
It's the right decision, but it is not a clear-cut case where the DNA says he had nothing to do with it. I mean, as a defense attorney, I always think, why not test it? And it was 7 years in the making that this test was put off and put off. What the DNA test showed is that there was a boyfriend of the victim who apparently was a match for the DNA, not the gentleman who's been on death row for 30 years. But the gentleman who's been on death row for 30 years did have the woman's checkbook, did have her personal belongings. And his story all along was, I was robbing her while she was having a fight with her boyfriend, and that the boyfriend is the person who did it. The boyfriend's in prison on other charges, and the question now is, will the state go back and retry him with this new DNA evidence?
Janet, so many people hear those letters DNA, and we think back to high school biology and
Right.
this notion that science can solve everything. What you're telling us in this case is that there is a limit to the context of DNA. How would you describe the parameters of the use of DNA in a court of law or in reconsidering some of these decisions?
That's a great point, because you would think DNA gives you the answer, but in this case, it actually raised more questions, and then a jury may be considering that. But in this case, when he went to trial 30 years ago, there was some DNA that the prosecution argued was a match for him, that there was a possibility that it linked him, along with the circumstantial evidence, to this murder. About 10 years ago, the Innocence Project started working on this case, and they said, well, we think the DNA matches somebody else. It wasn't automatically tested, and then it was ultimately put in the data bank, and it came up positive for the boyfriend, the person who was the other suspect in the case. So while DNA can say someone else was there and his semen may have been involved, there was a rape, and so he obviously was there and was involved in some fashion, it doesn't necessarily rule out everybody else. I mean, just because this guy's DNA wasn't on the evidence doesn't mean he wasn't involved in some way. So a jury, had they heard that, their verdict might have been different, but it might have been the same. And that's where there may be a new trial because of that.
Well, Janet, John Bachman here. I want to expand this out just a little bit bigger and take a look at the death penalty itself here. And as we see more and more DNA evidence being used to take people off of death row or acquit people and overturn sentences, as in this case, and also we have this issue with the drugs that are being used coming into question here. Do you see this mounting? In which one of these do you think is going to have a bigger impact on the death penalty moving forward?
Well, as a defense attorney, it's the kind of thing I would use. I would use both of those arguments. But on the other side, if you're on the law enforcement side, it seems to me that you should get behind testing DNA. That 7 years ago, had they said, yeah, let's go ahead and test this, let's find out who it is so we know what the answer is, it would just in one fell swoop get rid of all of those defenses. And just because, again, the DNA came up for somebody else doesn't mean they couldn't retry it. 7 years later, that trial is going to be a much harder trial to put on, so they may have hurt themselves. The same thing with the drugs used in executions. Just get rid of these drugs. Don't use drugs that you can, keep secret, and then when there's a botched execution, the defense immediately can say it was because of the drugs. They need to either go to new drugs or a new method of execution.
Well, Janet, continuing the discussion in terms of public policy and capital punishment, I guess it was about a decade ago in the land of Lincoln, the state of Illinois, when George Ryan was the governor, and DNA, it was almost a road to Damascus experience for Governor Ryan, who ironically, because of some other problems, ended up incarcerated himself. But he did a complete 180 on the whole notion of capital punishment. Do you expect, with, again, this combination of the difficulties with drugs and the rising prominence of DNA in this discussion, to see similar circumstances with other governors, or perhaps in the courtroom of public opinion, if you will?
Yeah, I mean, it would be interesting, and you know the players better than I do, JD, but I think Oklahoma would be one of the places where you might have expected something like that to happen after that execution went so wrong and so publicly. But I think that either these governors are going to say we want to have a moratorium on the death penalty, or they're going to come up with some method that may not be a new method, may go back to the electric chair. Here in Florida, that's what we used to use, that they may just have to switch and get rid of these drugs altogether, because they're going to have a harder and harder time getting the drugs that are used. I mean, there's no doubt about that. And that's going to either lead to the demise of the death penalty, or they're going to have to switch it.
Janet, we want to address another case. It's been called the case of the Cannibal Cop, which I don't mean to make light, but that almost sounds like one of those Earl Stanley Gardner, Perry Mason novels. The case of the Cannibal Cop, a judge has let this cop go free after nearly 2 years of incarceration. Take a listen to what the cop's attorney had to say, and then we'll visit to get your reaction on the back end of this.
This case is not just about Gill Valley. It's about really the bedrock core values of our legal system, that here in this country we still do have freedom of thought, and the government shouldn't be in our head and can't be in our head.
Janet, what is your response on this? Didn't it go a step further in this case? He wasn't just researching perverse things on the internet. He was actually using the police database to pull up names of real women. So it appeared he was using the assets of the state and of crime fighting to be involved in stalking.
Right, and this is where the legislature usually comes back and passes a new law because they don't like the result of the existing laws. In Florida, when Casey Anthony was acquitted, people wanted to go back and say, well, let's have Kaylee's law so we make it a crime not to report that your daughter's missing. This is a case where, yeah, I can understand you don't want to punish him for his thoughts, and I agree technically that's not a crime, but is using the government's money to potentially commit a crime, is that another crime? Well, that might be the way that they could have gotten him. And I think the legislature will have to go back and say, all right, technically this one may have slipped through the cracks, but how do we prevent someone from abusing his position to potentially hurt people? Because you don't want to wait till he commits the crime to then punish it. You want to try to prevent crime.
Janet, of course, it's an interesting situation. We talk about Monday morning quarterbacks.
Right.
For defense attorneys watching the different strategies being utilized, I'm just kind of curious, in the case of the so-called Cannibal Cop, what kind of defense do you think you would have mounted had you been legal counsel in that case?
Well, she did a great job. I mean, I can't second guess her because I think she was right. But what I try to do is turn to my clients and say, all right, we got you off on this, on a technicality, but between you and me, I want you to get help. I want this to never happen again. And let's take this bad situation and we made it into something, good for you, but let's also fix this problem, because this guy has a serious problem. I mean, there's no doubt about it. And 2 years in jail didn't fix the problem. His life's ruined. He's not going to be a police officer, but is he going to hurt people? That would be my concern. Her defense was right. I mean, he did have these thoughts, and not having completed the thought, that is not a crime. I mean, that's an absolute defense. But at the same time, is this somebody who needs help? Absolutely.
Janet, of course, I used to serve in Congress, and certainly
Yes.
a lot of people say congressional ethics is an oxymoron. But take me through, all kidding aside, the ethical constraints that defense counsel finds itself under, because I think a lot of people take a look at those who weigh in as advocates for a defendant saying, oh, they're just trying to get a guy off. What
Right.
kind of checklist do you have to go through professionally, ethically, when you take on a client?
Right. And I think we're probably even less popular, JD, than Congress.
Oh, that's saying something.
Until people need us, and then they like us. But I do think that I've been asked hundreds of times, I've been doing this for 20 years, what do you do when you have someone who's guilty? I don't even ask people, did you do this? That isn't part of the defense. The state has to prove that my client did it. And I'm proud to hold them to that burden. I think that's an honorable job. And, we don't want an unfettered criminal justice system where the only side is the police and the prosecution. We have to hold them to that burden. But at the same time, if my client tells me I'm committing a crime right now, I have to turn him in. I cannot represent him. I can't suborn perjury, nor would I ever do that. I mean, I hold myself to as high a standard as the Florida bar, if not higher. So I think defense attorneys, we're not out there to try to help crime get committed. I just want the government to make sure that they did what they had to do. The perfect example is the Supreme Court recently ruled, and you can say whatever you want about the Supreme Court, but they got it right on the cell phone search. The police, if you want to look at people's cell phones, you've got to get a warrant. It's not hard to do, to follow the rules. I follow them, and the other side has to follow them too.
Guides against unreasonable search and seizure, and also we have to remember the rights of the accused and the presumption of innocence. The burden of proof is on the state to make the case. Counselor, we certainly appreciate your insights, and thanks for not running the meter on us today, given it to us for free. Criminal defense attorney Janet Johnson, we look forward to having you back and getting your insights again in the days ahead. Thanks so much.
Thanks, guys.
So, Janet weighs in on a couple of important public policy issues and a couple of notorious cases. Your take on those issues invited and encouraged. Why don't you tweet us your remarks at Newsmax TV, # America's Forum. There's also email. Our address is connect@newsmaxtv.com, and you can visit us at facebook.com/Newsmax. America's Forum will continue.